Hello everyone, welcome in. We have some new court documents in the Alexee Trevizos case. The state has responded to Gary Mitchell's motion to dismiss and suppress evidence based off HIPAA privilege. It is a pretty solid document. There are a few issues, as you will see here. It is not the typical attorney. It is a stand-in attorney, as the attorney that will be trying this case is on medical leave. So it is likely that this attorney just got given this case, as well as other cases, to take over for the period of time that the trying attorney will be out. I believe, other than a few discrepancies, this is a solid response and the case will not be dismissed. There is a pretty glaring error on paragraph 8 here, as far as it being stated that life-saving measures were taken on the baby, and we know that to not be true based on the witness statements. So that will obviously have to be addressed, and some of the other discrepancies may have to be addressed when they do go to court here in a week or so. But nonetheless, those aren't big enough issues to get this case dismissed or this response to not be valid. So from there, let's just check out, there's essentially some pretty solid law that is stated throughout this. The issues that were brought up by Gary Mitchell were he was trying to, number one, get the case dismissed, but number two, since he knows that's not going to happen, try to get all of the medical information suppressed. And by medical information, if you watch the video that I did about the motion to suppress, he really wanted all of Alexee's incriminating statements and all of the statements that very much show Alexee's intent to deceive and to hide this baby. He did not want any of those statements in, and he's trying to use HIPAA to get those statements out, seeing as those were made to medical professionals. Well, it appears here that actually in the state of New Mexico, let's just go directly to my breakdown of these court cases. The state of New Mexico, the Supreme Court in the state of New Mexico recently decided on an issue in a case of State versus Lucero, in which a driver was in an ambulance. A police officer was getting on the ambulance when the driver was being asked by the medical professionals, the EMT, paramedics, what have you, if they had consumed any substances. And the driver admitted to having 3 alcoholic beverages. Well, that was then used as probable cause to start the DUI. So the issue was privilege, was that to be a privileged statement since the driver made it to EMT, paramedics, and, in turn, medical professionals? Well, the decision, it turns out, is that if the police officer is visible, the defendant can see and know that the officer is present when making incriminating statements, then those statements are valid to be used as evidence. Alexee obviously knew a police officer was in the room. She may be 19, but once you're 18, you should be expected to know your rights, because you're not entitled to a parent present anymore. You should know to, I'm just a paralegal, not legal advice, just don't speak unless you have an attorney present. I'm not a lawyer, but that's pretty much common sense. Give as much information as legally required to the police and don't volunteer any information. Hashtag I'm not a lawyer, this is not legal advice. But that's basically the argument for these first 2 cases, is Miranda rights, which we discussed in our video again in the motion to suppress, that TV and movies kind of make people think like a suspect needs to be Mirandized or someone in custody needs to be Mirandized immediately as soon as cuffs are taken out or as soon as they are told they're detained. But that's not the case. Only when someone is under direct interrogation by someone under color of law are they needing to be Mirandized. Sorry to be so choppy with that. Just because the cop is around you and you are you're being detained. It does not mean you have to be Mirandized. And that leads to what I was just saying before, which most attorneys will tell you: be quiet when the cops are there. Don't say anything more than you're legally required to, because, again, anything you say will be used against you. Even before you're Mirandized, you're incriminating yourself possibly. So just be quiet when the cops are around. Anyways, they put a really good point in here that the police even try to stop Rosa from questioning Alexee in their presence, which is, again, a great point. They're like, these cops weren't trying to coerce statements out of Alexee in any way. She and her mom were essentially talking about everything in front of them, and the officer is the one who told them to stop, which looks good for the police and for the state. That no one was trying to entrap anyone. No one was trying to coerce statements, like I said. And then number 3, it's still pending as to what will happen with this, and I'm even up in the air legally as to what the judge will decide. I kind of lean towards the idea that the judge will allow attorneys to argue for and against each piece of evidence as they see fit. Because essentially an in-camera review is asking the judge privately to look at it without either attorney arguing the evidence. So it would be anything that even has a sniff of a whiff of HIPAA, the judge would look at and make their own decision, and that would not allow either side to argue. And essentially what the state is saying in this is, no, please let us argue this. I would rather you not do this outside of our presence. I would like to make arguments for the evidence. And it seems as though they would only do that if they are really confident that the law will actually back them up. So I'm hopeful that come the 22nd, I believe it is, that they have this hearing, that we will have a decision as to a lot of these questions. But I do think that it will go to the side of the state just a little bit more, because not only will this issue be talked about, but also what will be my next video, I'm posting it right after this video, is the other motion about her trying to have contact with Devin. Both of these things will be discussed, and I think the judge is going to see what's going on here, and I'm not sure if the judge is going to really put their foot down for the first time in Alexee's time with being, with the law, or if she's going to continue to get the car brought around for her, so to speak. But the judge may or may not want to put their foot down, seeing some of the games that are being played and some of the BS motions that are being filed, and that the law is in the state's favor on a lot of this. We will see what happens when they come to that. I speculate more about what the judge may or may not do in regards to Alexee in the next video, because that has to do with conditions of her bond and her bail, and whether or not maybe they would, take it away or not. We'll have to see. But again, the state is asking to discuss all this at the hearing. And so we don't have solid rulings yet, but we will probably see some rulings come out right after their hearing. So I'm looking forward to that, and I will keep you updated if we do get any rulings before that, if the judge says anything or we get any more motions. But as far as it goes, things are looking up for us in the case right now. I think despite the couple issues and flaws and the discrepancies in this response, that the factual evidence that is not even anywhere near HIPAA will show the judge, obviously, this can't be thrown out. They're going to keep trying to do anything they can. Gary Mitchell was basically obligated to ask for a motion to dismiss. That's very standard practice in criminal cases, especially ones like this. We'll see if it works. It's my lowly paralegal opinion. It's not going to work, and we will see what the judge officially says on hopefully the 22nd, if they get everything filed and all the information gets out right away. Thank you so much for listening this far. If you haven't done so yet, please subscribe if you are interested in following this all the way to trial. I am trying my best to present facts and then sprinkle in a bit of my lowly paralegal opinion. Thank you so much for listening this far. If you haven't done so yet, please subscribe if you are interested in following this all the way to trial. I'm hoping for a guilty verdict, but it does not mean I will not objectively look at the facts. So I will see you in the next video where we talk about her motion to try and see Devin, and I'm pretty pumped up about it. So I will see you there. Thank you so much for listening. It's your girl Friday. Okay, bye.